Hello, my name is Francis Nerick. I'm the Associate Vice President of Certification Credentialing for the ACSM. I'm so excited to provide you all a sneak peek at ACSM's newest course in Law for Fitness Managers, Protect Yourself and Your Business. The Law for Fitness Managers course was developed by Dr. Joanne Eikoff-Shemek. She's a professor emerita of exercise science at the University of South Florida and the president of the Fitness Law Academy. Dr. Eikoff-Shemek's teachings and research have been focused on the fitness safety, legal liability, and risk management issues for more than 35 years. The purpose of the Law for Fitness Managers course is to provide fitness managers and aspiring leaders an inside view of negligence lawsuits in the fitness facilities and lessons learned from each case. Go ahead and type your questions in the chat bar and we'll respond them to the end of the webinar. And without further ado, Joanne, the floor is yours.
Okay, great. Thanks a lot. All right. Let's see. First of all, I still see myself and you, Francis. Is there a way I can delete that so I can see the slides? Okay, I still can see myself. I can't see the whole slide. All right, can we fix that? Oh, here we go. All right, very good. Thank you. All right, we're ready to roll. Thanks a lot, everybody, for joining the webinar today. I appreciate you taking the time out of your busy schedule to learn about this new ACSM CEC course called Law for Fitness Managers. I first want to point out the disclaimer at the bottom of this first slide. The educational information contained in the PowerPoint slides should not be construed to be the provision of legal advice. For individual legal advice, it's necessary to obtain legal counsel in the jurisdiction where appropriate advice can be provided. Okay, so the purpose of the course, first of all, this is a self-study CEC course. It focuses on the #1 responsibility of all fitness managers, and that's to ensure or help ensure the safety of their members and program participants. As you all know, injuries occur in fitness facilities and programs, and often these injuries result in a variety of negligence lawsuits. And as you also know, lawsuits are very costly and they may take years before they are settled or go to trial. So they create a great amount of stress for fitness managers who will likely be named as a defendant in negligence cases. Lawsuits are also very time consuming. Fitness managers will spend a considerable amount of time meeting with their legal counsel, providing testimony under oath, meaning answering questions from the plaintiff's lawyer under oath, and submitting various documents as requested by the court. So the purpose of this course is to provide fitness managers with the legal and risk management education needed to prevent injuries in the first place and avoid litigation. Fitness managers or those who are aspiring to become managers enrolled in the course will review negligence lawsuits that have occurred in fitness facilities and programs and take away many of the legal and risk management lessons learned from each case. So this course is designed for fitness managers who work in any setting: corporate, university, college, commercial, community, government, hospital, clinical, and retirement centers, to just give a few examples, and have titles such as the following: fitness manager or owner, fitness director or assistant director, personal trainer or group exercise coordinator, clinical exercise coordinator, head or assistant strength and conditioning coach, and entrepreneurs who are, in essence, managers of their own business. So all types of managers would benefit from this course, and supervisors in various fitness facilities and programs. The course is made up of 5 modules, and we'll talk about each of these and go over kind of a brief description of each here in a few minutes. The first is U.S. law, legal liability, and risk management. Module 2 focuses on negligence and common defenses to negligence. And then module 3, looking at the legal liability risk related to hiring, training, and supervising employees. And number 4, legal liability risk related to equipment and facility issues. And number 5, the risk associated with emergency planning and response. So the assignments for each module require you to read some excerpts from the required text. Law for Fitness Managers and Exercise Professionals. And again, there's a photo there of the textbook and that it's available through Amazon. And then I have prepared PowerPoint slides for each module. And for each module, there are about 50 to 60 slides that actually do a comprehensive review of the reading assignment. And then also I prepared a recording of the PowerPoint slides to give a little bit more context and explanation of the content in the PowerPoint slides and from the reading assignments from the text. So once you have completed the reading and going over the PowerPoint slides and recording, you will definitely be ready to take the CEC quiz. And there are about 8 to 10 multiple choice questions at the end of each module. So we guesstimate the time for each module to be about 2 to 2.5 hours at the most. And some of you probably can complete the modules even faster than that. In terms of the textbook, the required text for the course, it's divided into 2 parts. Part 1 gives kind of an overview of the law, legal liability, and risk management, and there are 4 chapters involved in Part 1, as you can see there. And then in Part 2, we cover the legal liability exposures and risk management strategies for each of these 7 areas. So there's a chapter on each of these 7 topics, chapters 5 through 11. And so you'll be reading excerpts from various chapters with the CEC course. And I do want to point out the definition of legal liability exposures. These are situations that create a risk of injury or reflect non-compliance with federal, state, and local laws. So each chapter begins with a description of those legal liability exposures and discussion of several different types of legal cases. And then the second part of each chapter gets into the risk management strategy. So these are things that you can do to help minimize those legal liability exposures. So the text covers the what, why, and how. What laws do managers need to know? Why do fitness managers need to know the laws? And of course, how do fitness managers apply the laws? So the what, why, and how is really the focus of the overall focus of the required text. Some of the general learning objectives for the course, obviously, to describe the basics of U.S. law as applies to the fitness profession, defining risk management and the 4 steps in that planning process, describe negligence and 2 major defenses to negligence, the primary assumption of risk and waiver defense, which we will briefly discuss today. The difference between standards of care or legal duties and standards of practice that are published by professional organizations, and identifying the major legal liability risks facing fitness facilities and programs regarding personnel, scope of practice, instruction, equipment, facility issues, and emergency planning. And then explain the legal and risk management lessons learned from the negligence lawsuits that occurred in the fitness facilities and programs. And then also to distinguish legal forms. Waivers and membership contracts would be considered a legal form, and risk management forms such as screening questionnaires, lesson plans, incident reports, and injury reports. And then to develop and implement a comprehensive risk management plan to minimize injuries and subsequent negligence lawsuits. So in the textbook, there are over 100 cases described, including 30 spotlight cases. The spotlight cases are where we get into giving kind of a comprehensive review of the case, starting out with the facts that occurred in the case, what was the issue that the court had to address in the case, and then what was the court's ruling in the case, and then the court's reasoning or their rationale for their rulings. So we go through kind of like an abstract or a summary of the case from beginning to end. And the CEC course, though, covers 26 cases, including 9 of the spotlight cases. So again, a sampling of all of the cases that are covered in the book. This is just a little bit about my bio, a little bit about my background in the legal and risk management area over the last few decades. I also have here, if you want to read a complete bio, the link to my website. I also want to mention that you can email me or contact me via the website. So if you have any questions after today's webinar, feel free to contact me. I'm happy to answer any questions that you might have. Also, I'd like to mention that, I have had the honor and privilege to serve ACSM in various capacities over the last 3 decades. And I'm really excited about this opportunity to have developed this new course. And I want to give out special thanks to the ACSM staff members, Francis, Catherine, AJ, and Shelby, for all of their help in the development of this course. It's always great to work with such excellent staff members at ACSM. So a big thanks to all of them for making this course happen. So now we're going to take a brief review, I guess, of each of the modules, and kind of so you get a flavor of what some of the topics are in each module for this course. So the first one is the U.S. law, legal liability, and risk management. There's a general description provided there, but I'd like to focus more on the objectives, which are a little bit more specific. So some of the content covered in the first module would be listing and describing the major functions of each branch of government, describing the differences between civil law and criminal law, explaining pre-trial, trial, and appellate court phases, outline the 3 levels of fault under tort law and the 4 elements of a valid contract. It's important to understand there are all types of law, but tort law and contract law are very relevant to the exercise profession, and so that's what we emphasize in the court, or in this CEC course, is the tort law and contract law. And then describing injury claims data and explain the types and causes of injuries and defining risk management and some related terms. And then summarizing the major components of each of the 4 risk management steps, and then begin building a comprehensive risk management plan and a safety culture. So as an example, this is some information from chapter 1 in the text, the fault basis of tort liability. Again, the 3 levels of fault: intentional, negligence, and strict liability. And the course really focuses most on negligence, harm due to careless conduct, gross negligence, and ordinary negligence. And I'll talk a little bit more about each of those here in a few minutes. And then the 4 elements, essential elements of negligence. These are absolutely important for the plaintiff to prove. So if the plaintiff wants to win, the plaintiff is the injured party who filed the lawsuit. If the plaintiff wants to win, they have to prove all 4 of these elements. And first is duty. What duty did the defendant owe to the plaintiff? How did the defendant breach that duty? So was there a breach of duty? And then causation. Did the breach of duty cause any harm? And of course, they're going to be seeking monetary damages for the harm from the injury. So it's really important to understand that negligence, the plaintiff has to prove that the breach of duty caused the injury. And because injuries can be due to all kinds of reasons, but in negligence, it must be due to a breach of duty. So contract law basics, 4 elements of a valid contract: agreement, consideration, contractual capacity, and legality. We give a an example here with waiver, waivers or release of liability. Waivers obviously are contract, and so in terms of the agreement element, the fitness manager offers a new member a waiver contract to read and sign. The new member accepts the offer, agreeing to the terms of the waiver contract. So you have an offer and acceptance. Consideration, the consideration or value that the new member receives is access to the facilities, programs, and services. The value the fitness manager and facility receives is the liability protection of the waiver. Regarding contractual capacity, an example would be a fitness manager who is under the influence of drugs or alcohol at the time of the contract would not be considered competent. And a new member who is a minor who does not have contractual capacity because of their age. So that would deal with contractual capacity element. And then the last one, legality. In some states, waivers are against public policy, and thus are unenforceable. And I'll talk a little bit about that here in a few minutes. Over on the right side of this slide, you will see examples of contracts that are often used in fitness facilities and programs, and we discuss all of these in various chapters throughout the text. So again, this is some information from Chapter 2 that's also in Module 1, the types and causes of injuries. You can see here on the left in the table, there's a list of all the different types of injuries that have occurred in these various lawsuits. And how did the injury occur is briefly described there. And then the name of the spotlight case where that injury occurred. So these are all different types and causes of injuries that have occurred in fitness facilities and programs. And we give one case example in Chapter 2, the Baldy Perry case. In this case, the plaintiff informed her trainer that she had known back and neck injuries. He told her that he had extensive experience training individuals with such injuries and that he could design a safe program for her. One day, he informed her that he had a new program for her, circuit training with no or little rest periods, that was being performed by many others at the fitness center. She reminded him of her injuries, and he indicated that she needed to trust him and that he was the professional and did this for a living. So relying upon his purported expertise, she performed the new routine as instructed and then suffered many severe permanent injuries, including herniated discs, surgery to remove, decompress, and fuse discs, ongoing pain and medical care, and even future surgery. So in this particular case, the plaintiff filed 26 negligent claims against the trainer and 16 against the facility. Also, the note there at the bottom of the slide is that the citations in the slide correspond to the citations in the textbook. So these were the 26 negligence claims against the trainer, and I'm not going to read through all of these. I'm assuming that all of you will have a copy of these slides and you can take a closer look at these at a later time. But a lot of it deals with the failure to conduct screening and proper assessments and proper prescription and so on. And then the negligence claims against the fitness facility dealing with improper hiring and training and supervision generally on part of the actual fitness facility. And we'll get into some of these a little bit more in a few minutes. So in this particular case, it's interesting because the trainer had a college degree in health, wellness, exercise physiology, and had obtained NSCA certification. This certification had lapsed at the time he trained the plaintiff. And the trainer testified that he did not obtain medical clearance as recommended by NSCA and stated that because he did not keep his certification current, he no longer had to follow the NSCA recommendations. So in this particular case, the jury returned a verdict of $1.4 million in favor of the plaintiff. So the key point here, and we have several key points throughout the textbook and throughout the CEC course. Professionals obviously should keep their certifications current, but if they do expire, that does not mean that the professional is no longer held to a standard of care of a professional, which I'll talk about here in a few minutes. Courts consider various factors when determining the standard of care of a professional as described in Chapter 4 and also included in Module 2. The conduct or the behavior of the professional is a more important factor than the professional's credentials. The court will determine if the actions are inactions, in other words, a breach of duty. Did those actions or inactions of the professional reflect a breach of duty? So, and then also toward the end of Module 1, we get into these steps of building a comprehensive risk management plan. And obviously, first is to assess legal liability exposures, becoming aware of the laws, statutory laws, administrative laws, and case law, and then also reviewing published standards of practice from professional and independent organizations. And then step 2 is developing your risk management strategies, and they're all different types of risk management strategies. And we cover all of these in the textbook, but the real focus is on the loss prevention strategies. And these are strategies to minimize a risk of injury and also reflect compliance with laws. And then step 3 is the implementation of the plan, developing a risk management policy and procedures manual, and of course, staff training. And the last is evaluation both formative and summative. Formative is kind of an ongoing regular evaluation of plan, and the summative would be more of an annual formal review of the plan, where you review any changes in laws and publish standards and so on, and then make changes accordingly. So let's go into Module 2, negligence and common defenses to negligence. Again, there's a brief general description, but let's take a look at the learning objectives, which are more specific. List and describe the 4 essential elements that plaintiffs must prove in a negligence lawsuit. So we get into that in a little bit more detail. Distinguish between defenses that are legally effective and ineffective in protecting defendants, and defining the professional standard of care, and explain 3 factors that courts consider when determining the exercise professional standard of care or duty, and distinguishing between standards of care and standards of practice, and describe how standards of practice can be introduced into a court of law to help establish duty, and explain why primary assumption of risk was ineffective in legal was effective in legal defense in some cases and not in others, and then strategies that you can use to strengthen the primary assumption of risk defense. And then we look at factors that determine whether a waiver will be enforceable or unenforceable, and then explain why it's essential to have a competent lawyer prepare your waiver. So negligence is defined as failing to do something that a reasonable, prudent person or professional would have done under the circumstances. So omission, or doing something that a reasonable, prudent professional would not have done, omission, given the same or similar circumstances. So negligence is referred to as ordinary negligence or careless conduct. So for example, failure to conduct pre-activity screening would be omission, and improper instruction would be commission. Most of the cases described in the textbook and in our CEC course involve ordinary negligence, and some cases involve both ordinary and gross negligence. So gross negligence is defined here at the bottom of the slide. It goes beyond careless conduct. The defendant failed to exercise even slight care or diligence, or an extreme departure from the standard of care, sometimes also referred to as willful wanton conduct or reckless conduct. So again, negligence is conduct either by omission, a failure to perform, or commission, improper performance. Effective defenses against negligence. So just because a professional or a fitness facility is named as a defendant in a negligence lawsuit, it does not mean that they will be held liable. There are legally effective defenses available to refute or defend against the negligence claims. However, your best defense is to demonstrate that no breach of duty occurred. If the defendant has documented evidence that no breach of duty, it will be difficult for the plaintiff to prevail. So if there's no breach of duty, there can be no negligence. So documentation is emphasized throughout the course and throughout the textbook. Preparing and retaining documents will help demonstrate that no breach of duty occurred, an essential risk management strategy, again, emphasized throughout the text. Storing copies of documents in a separate location is also recommended in case the originals are destroyed or lost. So some effective defenses against negligence. We describe all of these in the text. We really focus on 2 that are the most common effective defenses: assumption of risk, such as the primary assumption of risk defense, and the last one on the page there, defenses based on contract law, such as a waiver or a release of liability. So we'll talk about those 2 just because they are the most common defenses against negligence. And then, of course, there are ineffective defenses against negligence. Some of these may sound legitimate, but they are not recognized by the law as legitimate. So financial cost, like it costs too much, or we don't have the staff time or resources. We didn't understand the law. Again, ignorance of the law is not a legal defense, and so on. There's several here that sometimes defendants think maybe are legitimate defenses, but they are not recognized by the law as legitimate. And then also in Module 2, we get into standards of care. We talk about each of these: the reasonable person standard of care, the professional standard of care, special relationships, and children. So the only one I'm going to be focusing on today is the professional standard of care. If a person holds himself out as having special skills or knowledge superior to that of an ordinary person, the law will demand of that person conduct consistent with their skill set. So according to Betty Vandersmissen, and Betty Vandersmissen was a very well-known legal scholar in our field. She was, highly recognized, her expertise and her many writings in the area of fitness law, sport law, and recreation law. And so I do quote her work several times throughout the book. I have tremendous respect for what she contributed to our profession. And she states, if one accepts responsibility for giving leadership to an activity or providing service, one's performance is measured against a standard of care of a qualified professional for that situation. So in this context, a qualified professional means a competent professional with credentials. And again, in negligence lawsuits, courts will consider the credentials of the professional, such as degrees and certification and experience. But more importantly, courts will consider the competence or the behaviors, the actions or inactions of the professional given the situation. So remember, a breach of duty is some type of behavior, a failure to act or improper action. For that situation, she defines these three factors: the nature of the activity, types of participants, and environmental conditions. So regarding the nature of the activity, if a professional is teaching something that is quite complex or an advanced exercise, that professional must understand what precautions are necessary to make sure that when teaching such an exercise is done in a safe manner, and that the individual is ready also to perform such an exercise, that might be quite complex or advanced or maybe high intensity. And then, of course, the type of participants, meaning really looking at the medical conditions that individuals might have and taking precautions regarding those medical conditions. So if they have known back and neck problems, or they have diabetes or heart problems or osteoporosis, whatever it might be, what precautions does the exercise professional need to take to make sure that the exercise is being taught in a safe manner? And of course, environmental conditions, an example of that would be like heat and humidity, considering heat injuries and precautions that are really important to help prevent heat injuries. So down at the bottom of this slide, you'll see here expert witnesses who provide testimony in many of the negligence cases included in this book described how the exercise professional did not take the necessary precautions regarding one or more of these three situational factors in designing and delivering an exercise program, and thus did not meet the standard of care or legal duty owed to the plaintiff. So now let's move to primary assumption of risk defense. Very briefly here, we get into this more in the course, but to be effective, there's three elements that must be proven. The plaintiff possessed full subjective understanding of the presence and nature of the specific risk and voluntarily chose to encounter the risk. So the knowledge and understanding of the risk the plaintiff possessed is a question of the court, and factors that courts will consider are the nature of the activity, for example, sport, recreation versus fitness instruction, and the experience of the plaintiff, a novice versus a well-experienced individual. So this will make a lot more sense when you take the course and read some of the cases involving the primary assumption of risk defense. So in Module 2, we'll describe cases where this defense was an effective defense, it protected the defendants, and also ineffective, did not protect the defendants, and why. And then also ways that fitness managers can strengthen the primary assumption of risk defense. The waiver defense, whether a waiver is enforceable is based on state law. And some states have statutes that prohibit waivers, and in other states, courts have ruled waivers as against public policy for personal injury. So for example, in New York has a statute that prohibits health club waivers. There's the title of the actual statute. And of course, Massachusetts, Hawaii, and Louisiana also have similar state statutes. And then in other states, such as Virginia, Connecticut, and Wisconsin, waivers are unenforceable based on case law or rulings from the Supreme Court in those states. So for example, the Supreme Court in Virginia ruled in the Hyatt case that waivers to protect against negligence for personal injuries were against public policy and therefore unenforceable. So the waiver defense, this was a spotlight case that we covered, the Stelluti case, and this was an injury in an indoor cycling class, and this individual, first-time participant, was provided only partial instructions and on how to use the bike, and the waiver was ruled enforceable by the trial court, the Intermediate Court of Appeals, and the New Jersey Supreme Court. So after Stelluti signed the waiver to join the gym, she participated in her first class. She told her instructor of her inexperience, and the instructor helped her to adjust the seat bike and feet pedals and told her just to watch and imitate her during the class. Shortly after class began, she rose to a standing position, the handlebars dislodged from the bike, and the result, and she fell forward with her feet remained strapped to the pedals. And after some assistance to detach herself from the bike and resting for 15 minutes, she tried to resume her participation, but had too much pain and had to quit. She went to the hospital, received medical attention after the incident. She was diagnosed with several injuries, including back and neck injuries, and her medical expert stated that 3 years after her accident, she still suffers from chronic pain associated with myofascial pain syndrome. So she sued the facility and filed several negligence claims, and I'll just read a couple of these: failing to properly maintain and set up the stationary bike, and failing to properly instruct the plaintiff. So given that the waiver that she had signed, the defendants filed what's called a motion for summary judgment. This is a legal procedure that, for example, in this case, the defendant filed with the court saying, because she signed the waiver, there's really no legal issue here to discuss, and we are asking the court to dismiss the case. So the court in this case agreed with the defendants, and so they granted that motion for summary judgment. Of course, Stelluti was not happy with that decision, and so she appealed to an appellate court, the Intermediate New Jersey Appellate Court, and they upheld the trial court's ruling as well. And then she still was not happy and appealed to the top court, the New Jersey Supreme Court, and the majority upheld the trial and appellate court rulings. So what's interesting in this case, and the reason I bring it up, is because a dissenting opinion written by 2 of the Supreme Court justices, which we include in the text, and they give their reasoning why they disagreed with the majority and why they are really against waivers in health clubs. And this is just one comment they made in their opinion. Tort law is not just about compensating victims, but also about preventing accidents. By allowing a health club to eliminate its duty to exercise a reasonable degree of care, the majority has decreased the incentive for health clubs to provide a reasonably safe environment for their patrons. So again, it might help explain or kind of help fitness managers understand why some states have ruled waivers to be against public policy and therefore unenforceable. And so it just gives some good rationale for their reason. And generally speaking, courts don't like waivers. They don't favor waivers, but they don't want to interfere with 2 private parties and their freedom to contract. So we also in this chapter, or in this module, described 10 additional spotlight cases involving the waiver defense. And so these are briefly described in the textbook. What's interesting, out of these 10 that we do describe in this particular chapter, the waiver was unenforceable due to gross negligence in the following 4 cases. And so again, waivers are effective for ordinary negligence in jurisdictions where they are allowed, but not for gross negligence. So in all of these cases, the waivers were unenforceable because the defendants were found grossly negligent. So some quick things to remember about waivers: they do nothing to help ensure participant safety, and always to have a knowledgeable attorney prepare your waiver. Again, waiver law is based on individual state law, and state laws and requirements vary. So it's a very complex area of law. In the textbook, we cover a lot of these factors that need to be considered when developing a waiver. So again, that's kind of what the key point is mentioning there as well. So let's go to module 3, legal liability risk involving hiring, training, and supervising employees. Again, there's a general description there, but let's go to the learning objectives, which are a little bit more specific. Describe the various types of credentialing that exist in the exercise profession, a self-regulated profession, distinguishing between credentialed professional and a professional who is credentialed and competent. Explain why employees need to attain practical skills from a legal liability perspective. Define vicarious liability and direct liability, and list some case examples where fitness managers and facilities were found liable for each. The differences between general liability and professional liability insurance and their basic coverages, and develop staff training programs for newly hired employees that involves classroom and practical training, distinguishing between legal scope of practice and professional scope of practice, and creating a staff training program, and supervisory procedures for employees who are involved in pre-activity screening, fitness testing, prescription, instruction, and supervision. So this module covers excerpts from chapters 5, 6, 7, and 8 from the text. And it is the longest module, but it's also probably the most important, given the lack of or inadequate instruction and supervision is the most common allegation of negligence, according again to legal scholar Betty Vandersmissen. So many of the legal risk management topics are covered in this module, and only a few. I'm going to only describe a few of these. So all of you are familiar with credentialing. We are a self-regulated profession through accreditation and certification, and we are not government regulated through licensure or statutory certification. There's only one state, and that's the state of Louisiana, that has licensure for clinical exercise physiologists. So fitness managers need to have a good understanding of both vicarious liability and direct liability. Of course, you have a vested interest to hire credentialed and competent employees because they can be held liable for the negligent acts of their employees while performing their jobs through a legal doctrine called respondeat superior. It's a form of vicarious liability on an employer or a form of strict liability. So this doctrine was applied in almost all the cases described throughout the textbook in which the fitness facility, the employer, was named as a defendant based on the employee's negligent conduct. So very important, vicarious liability of employers, and then of course direct liability. Plaintiffs can also make claims against the employer based on direct liability, such as negligent hiring, training, and supervision, which is different from vicarious liability of an employer. So for example, in the Baldy Perry case, the plaintiff filed several negligence claims against the facility for their hiring and training and supervision failures. And here were some of those 16 claims, if you recall, in the Baldy Perry case against the employer: failing to have trainers who are certified or trained, negligently hiring, or hiring individuals who are not qualified, failing to offer appropriate and necessary training, and to make sure that the trainers followed rules and manuals and regulations and so on. So key point, employers have a vested interest to hire only credentialed and competent employees because they can be held vicariously liable for negligent conduct of their employees through the legal doctrine called respondeat superior, and they can also be directly liable for failing to properly hire, train, and supervise their employees. And so these are some cases in Table 5-5 here, dealing with direct liability claims against facilities for failing to properly hire, train, and supervise. And probably the most common claim is the failing to properly train employees. So why training is so important from a legal perspective. Again, it's very obvious in a lot of the cases that we cover that the defendants didn't have the necessary skills to provide a reasonably safe program. And those lack of skills led to improper actions, commission, or inactions, omission, which caused the injuries and the subsequent negligence claims and lawsuits. So you can see here from the figure, starting here with the lack of practical skills can lead to improper actions and inactions, which can lead to a breach of duty. If the breach of duty causes an injury, now you go, it can lead into a negligence lawsuit. So it all starts here. We talk about this gap between theory and practice. So again, courts will look at the competence of the exercise professional when determining whether or not that professional was negligent. So very important that they have the skills. And then at the end of each chapter, and this is just an example, at the end of chapter 5 here, we have this risk management audit. There's 10 risk management strategies listed here. Each of these are described in quite a bit detail in this chapter and all of the chapters. The second part of these chapters where we get into all the risk management strategies. So in this course, I'm going to focus on a couple of these out of the 10 that deal with hiring and training. So risk management number 5 and number 8. And so we get into those in a little bit more detail in the CEC course. And of course, all of these risk management audits, the very last strategy always deals with documentation. So again, this is some information from chapters 5, 6, 7, and 8. We get into the legal scope of practice and making the distinction here between legal scope of practice and the professional scope of practice. And of course, legal scope of practice, if employees are practicing medicine or dietetics or counseling without a license, it can lead to criminal charges. And of course, the professional scope of practice, very important that professionals stay within their knowledge and skill and experience and certification as they're practicing to make sure to help minimize, negligence lawsuits related to the professional scope of practice. So one quick example here, the Levy case in Module 3. This was a trainer, had a client with known osteoporosis, perform a series of jump repetitions on a bozo ball. After a few reps, she lost her balance, fracturing her wrist that required surgery. She filed a negligence lawsuit against the defendant, and the facility filed again a motion for summary judgment, a request to dismiss the case because she assumed the risk. And the trial court granted the defendant's motion, but the plaintiff appealed. And so the issue for the court was, did the trial court err when it granted the defendant's motion for summary judgment based on the primary assumption of risk defense? And the court said yes. The appellate court reversed the trial court's ruling, so the trial court was wrong. And the reasoning was the trainer, knowing that Levy had osteoporosis, unreasonably increased the risk of harm to her by having performed an advanced exercise. So the court looked at the nature of the activity, going back again to these 3 situational factors to determine the standard of care. So the nature of the activity, jumping reps on a bozo ball, and the type of participant, a client with osteoporosis, and determined that the exercise professional did not meet the standard of care for that situation. So I'm going to skip over this. These are just some of the lessons learned from the Levy case because of time. But again, in Chapter 8, we described several negligence lawsuits involving trainers, group exercise leaders, and other exercise professionals who failed to provide proper instruction and supervision. So let's go quickly into Module 4, dealing with exercise equipment and facility issues. Again, looking at the learning objectives, what are the underlying causes of equipment injuries that occurred in negligence cases, and how fitness managers could have prevented these injuries. Why it's important to follow specifications in the exercise equipment owners' manuals and to document that the specifications have been properly carried out. List and describe federal and state laws related to the management of a fitness facility, and looking at the legal duties that fitness facility managers owe toward invitees. Invitees would be all of your members and participants, and outline the topics to be covered in a facility orientation, and developing risk management strategies dealing with facility supervision and security, and legal issues regarding data privacy security when collecting personally identifiable information, and looking at the purposes of an incident report form from a legal liability perspective. So there are several types of legal liability exposures associated with exercise equipment. In the course, we focus on the negligence of professionals, again, improper instruction, but mostly focus on the negligence of fitness facility and managers and owners, and an example would be improper maintenance. So again, negligence of facility managers, as you all know, the fitness manager owner is the risk management manager and has overall responsibility for risk management for everything that goes on in the facility. So in this particular module, we cover some of these legal liability exposures related to exercise equipment. Those listed in red are the ones that we really focus on in the CEC course. So obviously installing equipment, this is an example in the Jimenez case, a spotlight case, and can lead to injuries. And this is an ASTM standard, the American Society for Testing of Materials, that specifies minimum clearances. So you can see you're 2 meters behind the treadmill and 0.5 in between the treadmills. So in this particular case, she sustained severe head injuries when her head hit the exposed steel foot of an exercise machine placed only 3 feet and 10 inches behind the treadmill. So when she joined, she signed a waiver, but she did not speak English, only understood the fee. The manager did not provide a waiver in Spanish, and he did not have a Spanish-speaking employee review the waiver with her. The facility knew it did not meet the spacing requirements, as stated in the treadmill's manufacturer's owner's manual. 6 feet was the standard practice, and the court said this was gross negligence, and so the waiver was not enforceable due to gross negligence. It was also not enforceable because it was administered with misrepresentation and fraud. In this case, the Chavez case, again, because of time, I'm going to just kind of quickly summarize this. Again, this deals with maintenance issue of a free motion cable crossover machine, and this individual suffered a traumatic brain injury, and they claimed that she and her husband claimed that the facility was grossly negligent because they failed to maintain the cross trainer according to the specs. So the trial court actually ruled the favor was enforceable, stating that defendant's conduct reflected ordinary negligence, but the appellate court reversed that trial court's ruling, stating that 24-hour fitness facility was grossly negligent based on the evidence. So again, expert witnesses provided evidence that the machine was not maintained according to the specs in the owner's manual. And some testimony from the 24-hour managers was quite interesting. One testified he did not know if the facility technicians were required to be familiar with the specs and if such manuals were even on hand. Another testified that the preventive maintenance charge was blank and therefore did not know if the maintenance was performed. So the court stated that the absence of such notations indicated that no maintenance was done. So they failed to exercise even scant care, and their conduct was an extreme departure from the ordinary standard of care. And then these are some of the topics covered in Chapter 10. I'm not going to take too much time to go over any of these right now, but definitely all of these are important, such as legal duties toward invitees, the supervision, obviously, maintenance and cleaning, technology and data privacy is very important. We know there are data breaches every day, and the importance of keeping individual data private and secure, and so on. So, and different insurance, types of insurance that facilities should consider purchasing to protect their business as well. And then the very last module, dealing with emergency planning and response. Again, looking at the objectives, federal and state laws applicable to emergent response and planning, and describing some of these cases in fitness facilities who failed to meet requirements as specified in state AED statutes. Explain why Good Samaritan laws do not apply to fitness facility employees and why while on the job. And then recognize that standards and guidelines published by professional organizations that require or recommend staff EAP training, rehearsals, drills 2-4 times per year may not be adequate. It's a good recommendation, but maybe not adequate. And develop and implement a written emergency action plan for evacuation and medical emergencies. And then assessing the knowledge and practical skills of your employees to help ensure they're competent to properly carry out the facility's EAP during and after an emergency. So there are various AED laws, and these are some examples. These are all states that have AED laws that are specific to fitness facilities and health clubs. They require the health club or facility to have an AED on site and to have an employee, an individual CPR AED trained. And however, each state might also have various other types of requirements. It's also important to understand that there might be other state AED statutes that are not specific to fitness facilities, but are applicable to fitness facilities. Do we need to finish up? Okay. I can't hear you, Francis.
Oh, no problem. Sorry. Of course, you think I would have it all figured out by now with the muting and unmuting. About another minute or so, and then because we have a couple questions that are coming in.
Okay. All right. Let me just finish up real quick. So again, this is the next slide just deals with some of these requirements from a California statute, AED statute. So the point here is that managers really need to know, understand all the requirements within these AED statutes. And of course, this next case is a Texas case. Texas does not have an AED statute for fitness facilities, but a different statute that was actually applied in this particular case, the bogus case. And so anyway, just again, the risk management audit again, and the focus on several of these risk management strategies in the CEC course. So this last slide here, you'll see the information, the link to go ahead and sign up for the course, and that the course that after completing the 5 modules and the CEC quizzes, you earn 11 CECs, and there's the information again on how to register for the course. I hope all of you will consider taking the course. I think you'll learn a lot from this course, and hopefully will be very helpful to help you manage your risk and to protect yourself and protect your facility. So if you have any questions, I'll be happy to answer them.
We have a couple of questions that are rolling in, Joanne. So a couple of them were related to waivers and how important is it to have a wet signature. So I think a lot of it now is just like with folks doing kind of online coaching, things like that. So when we're talking about doing waivers, what are your thoughts on having a wet signature?
I'm sorry, I don't know if I really, do you mean like for virtual fitness programs, for online?
Yeah, so yes, if you're doing an online program and you're asking for folks to do waivers, right. You can do it on a PDF and people type it in versus having a wet signature. Do you need to have a wet signature for like the waiver and liability?
Well, no, contracts can be signed electronically. That's been in effect for a long time. The concern is that the waiver needs to be revised in order to reflect some of those liability exposures that are unique for online training, as well as live streaming and on-demand, virtual fitness programs. So we do cover in the course virtual training, some legal liability issues, including a waiver, and a lot of things to think about there with the waiver for virtual training. But there are a lot of other legal issues and liability issues as well, and risk management strategies that we do cover in the course. And matter of fact, we just, in the last fitness safety column, the last 2, the one January, February issue and the May, June issue, we did a part 1 and 2 on virtual fitness programs and cover a lot of those legal and risk management issues. And of course, those are accessible on the ACSM website.
Next question for you is, how can an unsupervised 24-hour center like SNAP pass liability laws? It seems like this is an assumption of risk thing.
Yeah, that's another thing that we do cover in the module, in module 4, are risk management strategies for unsupervised facilities. And we know a lot of facilities are unsupervised or maybe partially supervised, certain hours where they do have staff supervision, but also a lot of hours where there is no staff supervision. And there are several risk management strategies to consider for facilities that are unsupervised. I think we have like a list of 10 in the textbook of risk management strategies for unsupervised facilities. So again, a waiver that needs to be very specifically written to cover things that come up in an unsupervised setting, and that's just one example. And there are many other things that they can do to help minimize their liability exposure. I'm not a big proponent of unsupervised fitness facilities, but do recognize, that they are, very popular, very common. But definitely attending to some of these legal liability issues is really important for the unsupervised facilities.
All right, we got 2 questions left. One's from the audience, and then I have one for you. Because I get to ask the last question for my own personal benefit. So this one is, I get this question all the time. If a fitness professional is employed by an organization that covers professional liability for employees, would you also recommend an individual policy as well?
That's an excellent question. Definitely, I highly recommend that fitness managers provide, obviously they have general liability insurance that they have for their facility and programs, but I also think they should provide professional liability insurance for all of their professionals who are involved in providing professional services like personal trainers and group exercise leaders and so on. But I would encourage exercise professionals to review that policy that the employer provides, if the employer does provide it, to review the policy to make sure that you are covered as an individual employee, okay? And if the fitness facility does not provide you with professional liability, I highly recommend that you purchase it on your own, and recommend going through a professional organization. If you're a member, you can get professional liability through like the Forrest T. Jones provider for exercise or ACSM members. The other thing is independent contractors. So managers that hire independent contractors, they must require that their independent contractor has verification of professional liability insurance, because that liability insurance only covers their employees and not independent contractors. So again, these are all good questions, and definitely you should always check with your legal counsel as well with some of these kind of insurance issues.
So I get to ask my personal question. Probably the most overused term, I think, what I hear within the fitness industry, scope of practice, and I think you did a great job describing it, because certifications are voluntary, and the purpose of those exams that we have for the CPT, EP, and CEC courses is really kind of establish a minimum professional competency. You have the knowledge, skills, and ability to do that, and if in combination with a degree, it just goes, okay, well, how do you know that they were competent enough to do their job? Now, if we can establish that, now what I have a question about is, if somebody injured themselves and the person was competent enough to do their job, how does one balance between the legal component of, like, okay, were they competent enough to do the job, and then the assumption of risk of the client? Because if the client does something that isn't supposed to be done right, and they've injured themselves and go, well, they weren't competent enough to do their job. So how do you as a professional kind of balance that, like the assumption of risk of an activity versus you as competent enough to do your job?
So I guess, thinking of, are you talking about, an individual who's exercising on their own in a facility and they hurt themselves? Or are you talking about an individual who is hurt doing something under the supervision of an exercise professional? Which scenario?
The second. The second. So it's like if you screened them out and they're running on a treadmill and they have a heart attack, like, I screened them. We didn't see that. They went through the proper channels. They just happened to get injured.
Right. And remember, in negligence lawsuits, and I think that's a very good question, Francis, because, and we emphasize this in the course and in the book, is that, remember, for a plaintiff to prevail or to win their negligence lawsuit, they have to show a breach of duty, that the breach of duty caused the injury. So if the plaintiff can show that, for example, the exercise professional failed to do something like conduct pre-activity screening, conduct a fitness assessment, design a proper exercise prescription given the individual's fitness and medical status. So that's what the plaintiff is going to try to show, is that the professional failed to do all of these things that would be considered the standard of care of an exercise professional,
Yep.
and perhaps a breach of duty, okay? And that the breach of duty caused the injury, all right? Because there's a lot of these cases, remember, there's cases in the text where the facility was not liable because the plaintiff couldn't prove negligence, all right, according to the court. And the court makes the decision, you know, courts determine duty, all right? Not the plaintiff, not the defendant, not the attorneys, but the court or the judge, okay? And how does the court determine that duty? A lot of times it's through expert testimony. And we have several cases in the book where expert testimony carried a lot of weight in helping the court determine that duty and whether or not there was a breach. Does that make sense?
Yep, it totally does. And this is the stuff I love this stuff. So awesome, friends. Thanks for joining today's introduction course. Joanne, what a wonderful resource this is for rising professionals and those who are managers to kind of minimize your liability as a professional. So this is awesome. Thank you so much for this. For those who have registered for the course, we'll send over the PowerPoint and then also for the recording as well. So look forward to taking the course, and thank you so much.
Thank you so much. Thank you for your time today. Appreciate it. Thanks for the opportunity,
Thank
Francis.
you. Bye, everybody.